Welcome back. I'm Stacey Delicat. You've been watching live testimony in the murder trial of Tex McIver, I should say, out of Atlanta, Georgia. And the judge right now calling lunch break. They will be on break for an hour and 10 minutes. And then when court resumes, there will be redirect and jury questions before the prosecution finally rests their case that has stretched on 3 weeks now. I'm joined now by attorney David Eisbrouch in studio, and via Skype we're joined by criminal defense investigator Charles Mittelstadt. So thank you both for being here today.
Stacey, great to be back.
Let's talk a little bit about what we heard before the lunch break. We have this witness on the stand who is a close friend and also a public relations expert who has been hired by Tex McIver after the charges are brought, Jeff Dickerson, to be his spokesperson. He's a crisis communications expert. We know he was a journalist in the community. He's a prominent personality on political panels in Atlanta TV. He's very well known. He knows Tex McIver well, and Tex McIver brings him on to try to right the ship, to try to get the story right in the press, right? Perhaps the most interesting thing we heard from Dickerson in his testimony was that McIver said to him, listen, if you can get these charges reduced, I will give you a bonus, and you can share that with whoever you want. And Dickerson testified on the stand that he insinuated that to mean that you can give some of the money to the DA. And Dickerson said that would be at best unethical, at worst illegal. He refused to do it. So, David, let me start with you. What can we make of that Jeff Dickerson is essentially testifying that McIver offered to pay, said, I'll give you money and you can pay the DA if he agrees to lower or drop the charges?
A couple of things. First of all, it's showing that he has a rogue client. The client is acting on his own behalf. He's not taking advice of counsel. He did not discuss this with counsel. He went directly to the PR specialist. It was totally unethical. It was illegal. It should never have been done. It shows a man in a desperate state. It's not good testimony for the jury. If anyone should be trying to communicate a plea to the prosecution, it's a defense counsel. That's what they're getting paid for. If there's such called a success fee, the defense counsel, even though success fees to pay lawyers can be unethical as well, that's their job. It's their job to get the charges dismissed or lowered or pled out, not your PR representative.
Right. And Dickerson said it's not uncommon for people in his industry, for PR professionals, to get a bonus or a success fee for getting the message across, while it may be for attorneys, as you said. But I'm curious, Charles, what was your take on this admission by Dickerson that McIver basically suggested he bribed the DA to drop the charges?
Well, that's the amazing thing, is actually on cross-examination, that's really not what he's saying. I mean, under cross-examination, Dickerson was forced to admit that he made certain assumptions based upon what McIver told him, and that in fact he never specifically uttered a bribe, or the fact that some of this money, part of the success fee, would be going or should be going to District Attorney Paul Howard. What he was basically doing was trying to buy access to Howard through Dickerson, who has this long-standing friendship with him, and I agree that it was ill-advised. I mean, this is the job of his attorneys to try to talk the DA out of a case or try to get reduced charges. But as has been the case from the beginning with McIver, is he's engaged in bad decision-making in the form of trying to shape narrative, trying to control spin. And this is an extension of that. But I think it actually is pretty favorable, this cross-examination, and to me, it's turning into somewhat of a nothing burger with Dickerson. It's very different than what the prosecution had argued the testimony would be in opening.
Yeah, well, that's a good point. I mean, we just basically heard the last 10 minutes, the defense cross-examining Dickerson saying, so he didn't tell you to give the money to the DA. He didn't say share the money with the DA. He just said share it with whoever you want. And what Dickerson said was, I thought it was an odd thing to say. His words left me with a distinct impression he was asking me to share this amorphous success fee with Paul Howard, the DA. So you are right on that. And then Dickerson also testifies, no, he did, in response to the cross-examination, no, he never brought it up again, and that was it.
Stacey,
David, go ahead.
If I may, and to Charles's point, it's a defense attorney's job to mince the words of the witness when he doesn't like what the witness said to the prosecution.
Right.
Now, basically, I respectfully disagree with Charles that it wasn't a nothing burger. I think the defense attorney, by prolonging the discussion, elongated that narrative that he didn't want the jury to hear. He doesn't want a jury to hear that, well, there may have been a bribe, it was insinuated it was a bribe, it was intimated. What were the exact words? Did he say to you, this is a bribe? Well, no, he didn't say it was a bribe. He's a lawyer. He's smarter than that. But he made his thoughts known very well to Mr. Dickerson, when Mr. Dickerson said, I distinctly thought he was telling me to relay the message to the prosecution. So I understand and I respect Charles's point of view, but it's a defense attorney, a criminal defense attorney's job to mince the witness's words.
Right, that is true. I mean, we'll have to see. It's all about how the jury interprets it. Let's go to a different point for a second, which kind of follows what we've been saying, which is that Tex McIver really wanted to shape his own narrative. This is the second public relations expert we heard from. The first was his friend Bill Crane, who he retained to speak on his behalf immediately after the case came to light. And now we're hearing from Jeff Dickerson. Jeff Dickerson says he parted ways with McIver basically after McIver decided to do a jailhouse interview with a local TV station without consulting him. Dickerson didn't think it was appropriate. He thought his advice was being ignored. What do we make that we're hearing over and over again that McIver is hiring people to help him, yet still wants to shape the narrative himself? Charles, what is your take on that?
We've talked about this extensively, Stacey. This is the problem with the case. From beginning to end, Tex McIver has been his own worst enemy. It's really, if you look at the physical, the ballistic, the firearms evidence, it's actually quite defensible. And it actually is completely consistent with the defense's accidental claim. The problem has always been Tex's own words and his actions. He has been his own worst enemy from the very moment that he was at the hospital all the way through to his jailhouse interview and his subsequent actions. And that's really the real challenge for this defense team, is trying to overcome Tex's own actions in this case. And also we've talked about how, as an attorney, he is used to controlling narrative. He is used to controlling spin, and this is a classic case of overthinking and trying to control the appearances in a way that have been hugely counterproductive for him in this case.
Yeah, I mean, I think that that's safe to say, and that, David, you would agree with that as well.
On this issue, I absolutely agree with Charles 100%. He's his worst own enemy. It's repeated during the trial. Instances where, one, he cut the check to the PR firm from the estate of his deceased wife. So
many bad optics in all of this,
yeah, he was going to go forward with an auction of her personal items, I believe, and then the PR firm strongly recommended against that, counseled against that.
And yeah, I mean, on those 2 points, well, yeah, first he pays Dickerson as retainer with the check cut from Diane's estate, and then he seems eager to get this estate sale of her furs and her jewels going, and when Dickerson tells him, call it off, that doesn't really look good, he says okay, but then decides not to call it off when he learns there'll be a cancellation fee. So not only is it bad optics, but he's starting to look like a guy who's really concerned about money.
Yes, and again, I agree with Charles that the physical evidence is very much in his favor. His testimony, not his testimony, but the testimony surrounding the shooting, I believe, does favor the defendant. And you have a very high standard here with beyond a reasonable doubt. Everything else is coming in as circumstantial. It doesn't look good. The optics are not good. At the end of the day, is it going to make a difference? Does it really tilt the scale that much? And the scale really has to be tilted dramatically in order to get a conviction here. But the optics just look terrible.
Charles, what's your take in terms of tipping the scales here? These little nuggets that we're getting. He cut the check for Dickerson from Diane's estate. He was pretty quick to auction off her stuff, and then when he found out there'd be a cancellation fee to turn it around, he said, never mind, let it go ahead.
Well, let's keep in mind, right now, this is the state's case in chief. We have not heard the defense yet, so we don't know what kind of witnesses they're going to put up. I suspect they're going to have some very specific legal arguments in response to this evidence, and that the estate sale in particular, which, by the way, I live in Atlanta, and I recall when the estate sale was announced, and to me it just seemed like a really bad optics. But my understanding is that sale was conducted at the urging of the estate attorneys in order to satisfy the will. And so I anticipate that there are going to be The state attorneys will testify and will clarify that issue. We heard from Bill Crane, and that's another one. You know, the Bill Crane, the optics are terrible with regard to that particular media consultant. But then when you get down to it, and he was asked whether he ever was asked to lie to the police or lie to the district attorney's office, which is which is one of the 3 influencing witness counts. He specifically said and affirmatively said no. So again, there's a lot of this is very incendiary for the defense, but then when you get down to it, and words matter, and so particularly when you have people that are forming impressions as to what text might have meant, the words absolutely matter, and so the jury's going to have to sort that out, and they're going to have to wrap their minds around whether this actually amounts to something or this is just really bad optics and ill-fated decision on Tex's part.
So, Charles, as you mentioned, we haven't heard from the defense yet. In fact, we were expecting the defense to begin their case this afternoon, but now it seems like the prosecution will continue after lunch. There'll be a little bit more redirect of the witness, Jeff Dickerson. There'll be some jury questions. So unclear whether defense will get started this afternoon or wait till tomorrow morning. But with that coming, knowing that the prosecution is getting ready to wrap up its case, we want to go back to the beginning when this all started a month ago, and we're going to be revisiting the opening arguments from both the prosecution and defense as we get ready for this next major phase in the trial. So let's go ahead with first some of the prosecution's opening arguments. Welcome back. We have just been going back in time about a month to the beginning of this murder case against Tex McIver, talking about the prosecutors listening to the prosecutor's opening statement. We just heard the first 6 minutes or so of that, and I am joined in studio by attorney David Eisbrouch. Via Skype, we have criminal defense attorney Charles Mittelstadt, who is in Atlanta. So when we go back and listen to the beginning of the prosecutor's opening arguments, it's pretty clear what they're going after here, and that's that Claude Tex McIver's motive here was money. Charles, I want to start with you because you're in Atlanta, right? And people knew who the McIvers were here. How well does this theory, the beginning of it at least, work?
Well, I think I think this is the opening argument is something that the defense is going to remind the jury about in closing, because so far, based upon the bit of the trial that I've been able to watch, the prosecution has fallen well short on delivering on some of those representations in there. We now know, based upon the examination of the state's own financial expert, we haven't even heard yet from the defense's expert, but just based upon the cross-examination and the direct examination of the state's financial expert, that, in fact, Diana was actually worth more to Tex alive than dead. So that whole, the money motive really has been severely attacked as it relates to the motive for a murder in this case. We also know that even post-mortem that Tex honored, and he wasn't required to, he honored this wish that Diane had to give the ranch to Austin by altering his own will. So there are several promises, several representations that were made in opening by the prosecution that simply have not materialized to this point.
And David, I want to get your thoughts, but I want to just mention that before this trial started here at Law&Crime, I actually did a Skype interview with those defense attorneys when they stated over and over again, Diane was worth more to him alive than dead. So obviously they're going to hammer home that point. So the prosecution building this motive on financial motive, will it stand? Will it work?
It's a great cliche, Stacey, that she's worth more alive than dead. However, when the prosecution opens up that she's worth $12 million and his income has dropped over 50%, I'd like to see the math on that, that if she is worth $12 million and she has assets, and if he is in the will or partially in the will, and whether these assets are liquid or not, or whether it has to be sold, whether they're securities, whether they're real estate, but worth more alive than dead, I don't know which way that's going to play.
And also it seems like a bit of an unorthodox marriage in that she gives him a loan, but it's not just pay me back when you can, honey. This is, there's a contract for this. There are terms. The ranch is on the line, right? Yeah,
the ranch is collateral for a $350,000 loan, which she gave him. I'm not exactly sure what the terms of the loan was, when they were repayable, whether she could call the loan at any time. But yes, Stacey, I agree with you. Unorthodox. I feel that if my wife or I have loaned each other money and there was a paper trail of it, the marriage wouldn't be lasting too much longer.
Right. But, you know, that's just one sign. It seems in many senses that the McIvers had a somewhat unorthodox marriage. We're going to be right back after this break. We'll have much more from the opening arguments and more analysis as we wait for the prosecution to rest their case after lunch break. Stay with us. Welcome back. We've been revisiting the prosecution's opening statements in the murder case against Tex McIver down in Atlanta, Florida. We are right now in a lunch break in court, and when court comes back this afternoon, the prosecution will wrap up their case, and then the defense arguments could begin as early as this afternoon. In the meantime, as I said, we are going back to where it all started. We are revisiting opening arguments, and I'm joined by David Eisbrouch, attorney here in studio, and Charles Mittelstadt is with us via Skype from Atlanta. He is a criminal defense attorney. And gentlemen, this is the second sort of chunk of the prosecution's opening arguments that we heard. But let me ask you first, what do we make about the point that was brought up repeatedly during the trial thus far, and that the prosecutor mentioned that Tex McIver never called 911. The driver of the car, Danny Joe Carter, never called 911. This gun went off, McIver alleges, accidentally. His wife is shot. She's not doing well, and no one calls 911.
Well, there's going to be contradictory testimony, and there has been throughout this entire trial. I believe the testimony from both the driver and the statements that McIver gave is that they wanted to get to a hospital as soon as possible. There's some contradictory testimony whether the driver wanted to go to another hospital first and McIver directed her to another hospital because he felt it was the better hospital. And I understand some of that testimony was not admissible as well. Not calling 911 to me is interesting, but possibly not shocking, dependent on how close you are to a hospital. If you're very close to a hospital and you're familiar with the area, you know, why call 911 to wait for an ambulance where you can get to an emergency room faster?
Yeah, Charles, do you agree? I mean, is there any negligence in not calling 911 in that case?
I do agree. In fact, I've actually retraced the route. Vinnie Politan and I did a reconstruction of this reenactment of the scene, and where Diane was shot is exactly equidistant to Grady, which was approximately 3.4 miles in one direction, and Emory, where they actually ended up going, which was about 3.2 miles. And so I agree. I mean, you're going to have people who are going to find it shocking that 911 was not called, but if arguably there's nobody who's going to be able to get Diane emergency medical care quicker than staying in that vehicle and getting her immediately to the emergency room. If you stopped and waited for 911 for an ambulance to show up, it's going to delay the process. So can you argue, yes, you could have called ahead so that maybe ER was on standby and they knew, yes, but also there has not been any evidence that Tex asked them not to call. He didn't say, hey, don't call 911. That would be problematic for the defense. We haven't heard that sort of evidence.
The other interesting part about the chunk of opening argument we just heard from the prosecutor is that there's one point in which we hear from Diane, the deceased, the victim in all of this, and that is when she is on the operating table, essentially. The doctor, the surgeon testifies, and I want to just replay the clip of video while we discuss that we just saw, which is of Diane getting wheeled into the Emory University Hospital after she's shot, when we saw Tex with her at her side. Clearly she's in a lot of pain, and we know once she gets onto the table that she's not doing so well. But we hear some different information in these opening arguments about what the surgeon, what the doctors on call will testify. And one thing is that Diane kind of changes her story in the beginning, but then she says it was an accident. So that kind of bolsters the defense's case right then and there. It's interesting to me, David, that the prosecutor brings this up right away in the opening arguments, that Diane herself says it was an accident.
Well, of course, it was brought up in the opening. The opening, as we all know, is not evidence. I'm not even sure if anyone during the trial testified that that's what she said to a nurse. I did see the testimony where she testified that it was an accident, that she told the nurse it was an accident before she was intubated. I did not hear any testimony by any medical professionals that she said she did not want to see her husband before she went to surgery. Maybe Charles can opine on that.
Charles, what's your take that the fact that Diane, the surgeon testifies Diane told her it was an accident?
She did, in fact, testify to that. And she also did mention that when she asked Diane if she wanted to see her husband, she said no. But she also acknowledged on cross-examination that that's not that unusual, that Diane anticipated living, and that perhaps she meant she just wanted to see him under better circumstances, maybe in an hour or two or the next day or whatever. So I think that that was kind of a wash, in that that testimony really goes nowhere.
Even the fact that Diane says it was an accident, because I mean she's the only one. She, I guess, and Danny Jo Carter and Tex McIver, they're the only three in the car. One of them is dead now, and Danny Jo Carter, I mean, we can opine that she maybe didn't know what was going on. Diane, you know, this is the only time we can sort of hear her perspective. The fact that she at least tells a surgeon it was an accident. I mean,
No. As to the accident, obviously, yes, that's significant. In terms of trying to read into this, she didn't want to see him, right, because that would infer somehow that maybe she thought there was something nefarious about the whole thing. That's what I'm suggesting, based upon the acknowledgement, the admission by the doctor on cross-examination, that that's not that unusual.
Yeah. So what we want to do now, David, did you want to add anything?
I was just going to say that, you know, taking Diane's testimony into consideration, whether she said it was an accident or not, obviously she had no way of knowing whether it was an accident.
Right.
She was in the front seat.
And she's presumably bleeding out on the table, you know, and who knows what her state was. We know there had been alcohol involved and so on and so forth.
When you hear a gunshot go off in the car and your husband's in the back seat, your first instinct is it was an accident.
Right.
You know, my husband wasn't trying to kill me.
Right.
If he wasn't trying to kill me, he wouldn't be on trial right now. There's obviously enough evidence, at least for the grand jury, that he is on trial. So I agree with Charles that I don't think much weight should be given to what Diane said under those circumstances, one way or the other.
So, gentlemen, we have about 30 to 40 minutes before court resumes from the lunch break. And before that happens, I want to now play some of the defense opening arguments. Again, we expect this afternoon or possibly tomorrow morning the defense team will begin arguing their case. So let's go to that now. Let's revisit the defense's opening arguments in this case. Welcome back. We've been revisiting the defense's opening arguments in the murder case against Claude Tex McIver. He is charged with murdering his wife, Diane, back in 2016. And we earlier listened to some of the prosecution's opening arguments. We just began some of the defense opening arguments. And I'm joined by David Eisbrouch, attorney in studio, and I have criminal defense investigator Charles Mittelstadt via Skype from Atlanta. So, gentlemen, we just heard one of the defense attorneys sort of getting into the forensics of all of this. And this is going to play a big part in the case, right? The gun was sideways, she said. It was never taken out of the plastic bag. It wasn't pointed at Diane. Certainly, those forensics will come to play a big part in the jury's deliberations. Charles, let's start with you. What's your take on that?
I know the gun well. It's a Smith & Wesson 38 revolver. It's got a shrouded hammer, which is a true carry conceal gun. It's a model 638. And the unique thing about it is the fact that it has this shrouded hammer. So when it is actually cocked, it's very, very difficult to discern it. It also makes it very difficult to uncock safely. And like all revolver, or most revolvers now, they don't have safeties, and that's inherently why I recommend against a revolver for personal protection for a female or somebody may have in her purse, because there is the possibility that it can accidentally discharge. So that is significant. What you also heard in opening argument has completely been borne out, not through the defense witnesses, but actually through cross-examination of the state's witnesses, and that is that the firing position is completely consistent with it being at lap level. You know, you can see the entry hole in the back of the seat is at lap level. We know from the examination of the state's firearm expert that probably the most significant thing that came out of that examination for the defense is the fact that not only could he not, but there is no expert in the world that can rule out the possibility that this was unintentional. And so far, everything that we just heard that the defense represented in their opening has actually materialized through the state's witnesses.
Yeah, I mean, and this point about whether the gun was in single or double action mode and no one being able to know, as you said, I mean, actually it is quite relevant which mode it was in, but we will never know for sure.
Has to be in the single action mode. I think it's inconceivable, and I don't think you can sell, I don't think the defense can sell the argument that it could have been in the double action mode and have a 12-pound trigger that was accidentally pulled. In the single action mode with a 2-pound trigger pull, even in the bag, which provides no resistance, it's very conceivable that just brushing the outside, not even putting your finger inside the trigger guard, but just brushing the trigger itself would have been sufficient to discharge that firearm, consistent with him having his hand on it. But I don't think there's any way that the defense can possibly sell this notion that the gun was in the double action mode. That's just a very difficult trigger pull at 12 pounds to pull accidentally. It's difficult to pull intentionally at 12 pounds, to be candid.
Right. Well, the defense couldn't pull it. They probably wouldn't want to, right? But the prosecution, maybe that's a different story. But
well,
David, you were just kind of...
Charles, whether it's in the single or double mode, you admit, and the defense admitted in their opening, that he is an experienced gun owner and has trained people in safe usage of the gun, correct?
Thus the recklessness of the whole thing. I mean, that's the problem.
So, I mean, whether it's in double or single, it's undeniable that he was pointing it toward the front seat at the time it was discharged.
Entirely reckless. Terrible gun safety, not good gun safety. So that's the problem in the case. And then if you throw alcohol in on top of that, you know, you have just a series of poor judgment that contributed to, by what looks to be, you know, an accident.
Right, because one of the charges is the aggravated assault with a deadly weapon, and because the felony murder rule, you know, that's really the underlying crime here.
I mean, and you have to think, again, this is just the opening arguments, and we are expecting the defense to begin their case either this afternoon or tomorrow. But you have to think this, you know, if you're in the jury, that there is a point here. If you're going to kill someone intentionally, there's certainly a more sure way to do it than first shooting through a car seat, right? Because, I mean, how do you even know? I guess maybe, Charles, you do know if you know a lot about this firearm and how it works. I mean, how can you be sure?
No, I agree. And
that
if you've premeditated this, and you've already premeditated the fact that you're gonna have a quote stage an accidental shooting, then why wouldn't you aim for a more vital area? Why would you aim at lap level through a seat, not knowing whether the inner workings of that seat and all the stuff that controls the electric seat, the reclining features and all that, not knowing whether that's actually going to stop the projectile? It just seems foolish. Why would you do it at that moment when you had just been on the road on Interstate 20, which, by the way, is a very, very isolated road for long, long stretches at a time? Why would you wait until you're in town in close proximity to a number of different hospitals? And so, based upon the state's theory, his intent would have had to have formed when they got off of that exit, because he had no idea. That was unplanned. They were supposed to continue on 85 and not get off at that exit. So, according to the state's theory, his intent would have had to have formed from that instant. And then within 8 minutes, he would have carried out this plan, because there's approximately 8 minutes that elapsed from the time they got off to the time that she shot.
And Charles, to your point, he would also be doing it in plain sight of the witness driving the car.
Right. Why would he do it with his best friend, wife's best friend in the car?
But also, to what Charles was saying before, it goes to the point that this was reckless, and it could be one of the underlying charges.
Right. I mean, I think it seems both of you agree that there was recklessness involved here, but whether that rises to the level of murder, to malice murder, to first degree murder is another
correct.
question.
To form the intent at that moment, as Charles indicated, when they're first getting off the road, off the main road, is a far leap to sell to a jury.
This case was originally charged as an involuntary and a reckless conduct case. You heard from Detective Smith, the lead detective, who, by the way, the prosecution attempted to impeach their own witness, the lead investigator in this case. They tried to impeach him on the basis of inconsistent statements, but he himself had testified that to him it was a reckless conduct involuntary manslaughter case. And so really, basically the Fulton County District Attorney's Office has ignored the recommendation of the Atlanta Police Department and pursued this as a murder case. And this all was triggered on the basis of a search warrant that was executed at his home, where they found a Glock in violation of the terms of his bond. And that's what put this whole thing in a very different light.
I guess as we get ready for the defense to start its case, the biggest question a lot of people have is whether or not Tex McIver will take the stand himself. We know during the course of the many months leading up to this trial and right after the crime, or the incident, I should say, he attempted to shape the narrative himself many times, going directly to the media, doing interviews, ignoring the advice of public relations professionals that he hired. So the question is, in this case, will he speak for himself on the stand? Would his attorneys even let him? Or does that just harm their case even more? Charles?
I can't imagine that he would elect to do so. Obviously, it's at the end of the day, it's his decision. He's in control of his own ship. But I think it would be a monumental mistake. I think this case has gone exceedingly well as it relates to the murder charge for the defense. And I think they have a couple of decent arguments with regard to the witness tampering counts. But I think it would be a huge mistake on his part, and it would undo all the good work that's been done to this point by the defense attorneys during their cross-examinations and whatever comes to follow during the defense's case. And he essentially erases all that and assumes the entire burden for freeing himself, because at that point it 100% comes down to his credibility. Either the jury believes him or they don't, but if they don't, then he's convicted himself. And that is a huge responsibility and a very foolish one to take on his own, in my opinion. But listen, we've seen him make foolish decisions up to this point before, and so you obviously can't exclude that possibility, but I certainly would not expect for him to testify.
Yeah, I mean, I would imagine his attorneys are counseling him not to. Do you agree?
Oh, absolutely. I agree everything that Charles just said, that it would be foolish for him to take the stand. There is certainly reasonable doubt on the murder charge, unless he's thinking to taking the stand on the aggravated assault with the weapon is going to help him out. He admitted to having the gun. He admitted to pointing the gun at the front seat. I don't know how that testimony would help him out at all. However, in a trial covered by Law&Crime a few weeks ago, where I was fortunate enough to be here, which was the Birch trial,
right.
A gentleman who murdered a woman after meeting her in the bar that night, and there was really no physical evidence. And I thought the prosecution's case was good, but there was still a question at the end. He decided to take the stand.
And we know it didn't work out well in his favor.
Didn't work out well for him. His credibility was terrible. He could not explain his whereabouts. He had a prior record.
He got a little aggressive.
He got aggressive. He got flushed, and the jury came back within an hour and convicted him.
Right. So that's a good point. I mean, clearly things can turn, and we have seen that Tex McIver is a rather unpredictable person who has, we know, told different versions of the story at different times. So
how much larger that he believes himself to be larger than life, and those are very dangerous defendants.
Right, right. And so, that will be something, obviously, we have to wait and see. Anything can happen. In the meantime, we are waiting for court to resume. It could be 5 minutes, 10 minutes, 15 minutes that the jury's back in the courtroom and the prosecution wraps up their case, and then we begin to hear the defense's case. In the meantime, let's go back now to a little bit more of the defense's opening arguments. Welcome back to Law and Crime Live. I'm Stacey Delicat. We have been replaying the defense's opening arguments in the case of Claude Tex McIver, charged with his wife's murder. This trial has been going on now for almost a month. There was a week break last week for spring break. The prosecution expected to wrap up their case in just a few minutes, actually, when court resumes from the lunch break, and it is possible that the defense's case will get underway this afternoon. In fact, we do expect that to happen. I'm joined in studio by David Eisbrouch, and via Skype we have Charles Mittelstadt from Atlanta, criminal defense investigator. Charles, I know you have to drop off in a few minutes. Before you do, what are your thoughts when the defense begins their case? What do you expect we hear first from them, and that they will stress first? Will it be that this was accidental? Will they go in to the financial circumstances that we heard the defense attorney just discuss?
I don't know the particular order of their case, Stacey, but I anticipate you're going to hear from their own financial expert. I anticipate they're going to call their own firearms expert. You'll probably hear from some probate attorneys, estate attorneys that were involved in decision making in this case, or at least in giving advice. So I think they're going to hammer away at those things. I think they've already borne out the important parts of their case through many of the state's witnesses, including Danny Joe Carter, Stringer, some of these other folks that, and also all the media consulting folks with regard to these witness tampering charges. So I think it's really going to be reinforcing the absence of any financial motive, giving a much more clear financial picture as to what Danny Joe's real net worth was at the time of this accident, as well as trying to dispel this notion that, as the state said in opening, that Tex was worth less than $1. That simply isn't true, and that was actually proven through the state's financial expert. So I think they're going to reinforce all those themes, and I think they're going to rest after that without calling Tex McIver as a witness.
Well, Charles, I want to thank you for your insight on this case. We know you know a lot being down there in Atlanta, having relationships with some of the defense attorneys. So we thank you, as always, for weighing in. And I'm sure we will be talking to you again as this case continues and as the second phase of the trial starts. So thanks again for being with us.
Great. Thank you.
Back here in studio with David Eisbrouch, we're going to switch gears for a second. Now, David, as soon as we get a signal back from the courtroom in Atlanta, we're going to go live there. But first, I want to talk about another case, a civil case, which we're going to be carrying live on lawandcrime.com. And it's an interesting one because it involves the magician David Copperfield. Now, this guy's known all around the world. He has TV specials. He has a Vegas show. And he is being sued by a British tourist who claims that he was left brain damaged when he participated in one of Copperfield's disappearing, vanishing tricks. This was back in 2013. He was at the MGM Grand seeing Copperfield for his birthday. He was selected from the audience, one of several audience members chosen for this disappearing act trip. He claims in the course of this vanishing act, he was injured. He's now been left brain damaged, and now he's suing to collect. David, you know a bit about this case because there's a Manhattan attorney who's working on it, right?
I do, Stacey. The plaintiff, Gavin Coxs, who is the British gentleman who was injured during the act, who coincidentally, not coincidentally, but part of the damages will, excuse me, include that he was a chef in England. He actually had worked for the royal family, I believe, prior to this accident. So part of his damages with the TBI, the traumatic brain injury, is that he can no longer work. He no longer has the earning capacity. I do know the attorney who was brought in to try this case in Las Vegas, and it's not uncommon that a local attorney that Mr. Cox retained in Vegas would reach out to a very well-known, prominent national trial lawyer like Benedict Morelli, who's in New York City. I know him as Ben. I've worked with Ben over the last 12, 15 years on civil cases. We worked on pharmaceutical cases together. Ben is one of the most prominent trial lawyers in the United States when it comes to personal injury matters, medical malpractice matters, pharmaceutical litigation. This is right up his alley. This is what Ben loves to do.
And I should mention, jury selection is underway in that case. Let's go right now to a 1-minute clip we have just recapping the case. We'll come back and discuss more of what we expect to see.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Coxs, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
Yeah, Gavin Coxs, the man suing here, says these injuries have turned his life upside down. He has pretty much constant pain. He has problems with short-term memory. So I think one of the most interesting parts about this case, right, is that Copperfield may be forced to reveal his secrets. What is the secret of this vanishing act? It will be laid out in an open courtroom, right?
Well, yes, and I know that Copperfield was deposed for this case. I have not read the transcript, but I imagine he was asked about the act. I believe there was some reporting that there was a fake stage where they were lowered down underneath during the act, and there was a tight tunnel that went from the stage area to the back of the auditorium where they were supposed to reappear at the end of the act. And it was in that tunnel, in that passageway, that the plaintiffs tripped, fell on debris. They're suing for the negligence of not keeping that in a free and clear and safe manner and causing Mr. Cox to fall.
It sounds like you think they have a pretty good case.
I absolutely think they have a good case. What's interesting is that Copperfield may be an entertainer in Vegas, and believe me, I have not pre-thought out this line, but Morelli is a showman in the courtroom. Ben Morelli knows how to work a courtroom. He knows how to work a jury. Interestingly enough, this is a bifurcated trial, meaning that the first part of this trial, they'll only be hearing liability, not damages. So the court has decided that they want to bifurcate the liability from the damage portion, meaning that the jury will only decide initially whether MGM and/or Copperfield was at fault for Mr. Cox's injuries.
Do you know what the damages are that they're asking for? I don't see it in published reports up to this point.
Well, they're claiming that Mr. Cox suffered what's called TBI, traumatic brain injury, due to the fall caused by the debris in the tunnel, and he can no longer work as a gourmet chef. He can no longer earn a living. However, they're also seeking punitive damages against MGM. That's where Ben Morelli tries to ring the bell for tens of millions of dollars potentially, because of the reckless manner that he's going to try to prove that they left this tunnel during this act.
Does this fall more on MGM because it's their property, or does it equally fall on Copperfield and his people because they are directing this stunt, this magic trick? They are responsible for this area, presumably they're tenants of this space.
Great question, Stacey. It all depends on what the contract and the agreement says between Copperfield and MGM. Whose responsibility is to set up the acts, to make sure they're safe. We know there are insurance policies in place for Copperfield and for MGM. MGM may have a self-retainment policy where they're paying out of their pocket up to a certain amount. Copperfield, we all know, is going to be insured. But to answer that question, it depends on what the agreement and the contract says between Copperfield and MGM.
Well, certainly a very interesting case, and to your point, the attorney in this, Ben Morelli, he tells the New York Post of Copperfield he's supposedly the most successful magician in the world, but he plans to use Copperfield's own words to show he's more of a trickster than a magician. So it will be certainly be interesting when it gets underway. Again, we are going to be streaming it live on Law&Crime.com, and from what you're hearing from your sources, jury selection still underway right now in the Vegas courtroom.
Still underway. Possibility they could start the trial tomorrow, if not possibly Thursday. I think it's a very exciting and interesting civil case for the network, who has broadcast criminal cases in the past. This brings together the elements of a great trial lawyer, a case involving negligence, very serious injuries, and a celebrity defendant.
And a celebrity. And interesting, to your point, that the plaintiff in this has some sort of high-profile ties, too, as a chef for the royal family. And I'm sure a lot of people in Britain are paying attention to this. I know the tabloids there have been covering the case because, you know, anything that has to do with the royal family draws big attention there. So that will certainly be interesting to see how it plays out. And again, as soon as jury selection is complete, we'll be streaming that on Law&Crime.com. In the meantime, let's get back to our other big trial now that we've been following for a month, the murder trial against Tex McIver. Court right now still on a lunch break. It is expected to resume any minute, and when it does resume, we will hear the prosecutors wrap up their case. We will hear from the public relations expert Jeff Dickerson, who was hired by Tex McIver. He will be back on the stand for a bit of redirect, and then the defense expected to start their case this afternoon. In the meantime, the past couple of hours, we have been revisiting opening arguments in this case. So let's go ahead now and play the very end of the defense's opening statements in the case. Welcome back. I'm Stacey Delicat. There's a little sidebar going on in the courtroom right now in the Tex McIver trial as the judge reviews questions from the jury. We have just heard testimony wrap up from Jeff Dickerson. He is a public relations specialist, a pretty prominent personality in the Atlanta area and a longtime friend of Tex McIver, whom McIver brought on to sort of help shape his image and redirect the message in the aftermath of this shooting. David Eisbrouch, attorney, in studio with me now. What we we spoke about before the lunch, what's been most interesting from his testimony really is that Dickerson testified that McIver offered him a success fee, a bonus, if he were able to get the charges against him dropped or reduced, and he said you can share that with whoever you want. Dickerson testified that he read that to mean you can give the prosecutor the money if he agrees to drop the charges. Obviously, defense attorneys have been trying to discredit that pretty aggressively.
And again, Stacey, what I said before about mincing the words, they're trying to really separate the words and the meaning. The defense is trying to say, well, that's possibly not what McIver meant. And you can see on the redirect and the follow-up, there are two questions. First, on the redirect by the prosecution was, again, to have the witness state that he was very clear what the defendant meant when he asked him to share the money as a success fee if he was able to get the charges dropped. Then the defense came up on their follow-up and basically just wanted to clarify, but he never actually told you who to share it with, correct?
Right. Yeah, Dickerson, and I quote, said, his words left me with the distinct impression he was asking me to share this amorphous success fee with Paul Howard, the district attorney. But that is just the impression that he got, right?
I think it's reasonable to conclude that the jurors are going to realize what McIver's intentions were here. And again, he was acting rogue. He was not acting on behalf with consultation of his attorney. It was a very stupid thing for him to do, especially being an attorney himself. Not a very smart move. Again, just one of the chips on, reasonable doubt, the gun going off. Now, we've said this ad nauseum, that it'll be very hard to convict here under the first-degree murder, but he is looking at the reckless use of the gun, and he's going to have a tough time getting around that. So all of this color, so to speak, to the case is not helping him on the lesser charges.
Yeah, that is certainly true. So just to recap, the judge right now reviewing some questions from jurors. After that, we expect the medical examiner to take the stand. Then the prosecution will rest its case. The defense may or may not begin this afternoon. David, something that came up this morning in court was an argument between the attorneys over whether or not to admit some pretty graphic autopsy photos during the testimony of the medical examiner. The judge ruled that some of the photos can be admitted while others that were more graphic will be left out. Is that any surprise to you?
No, the standard is always the prejudice versus the probative value of what the jury is going to see. They obviously saw the video of Diane entering the hospital. Some of that was graphic, but it wasn't too graphic. It wasn't anything that was offensive to the eye. The autopsy photos obviously are going to show more of the wound, more graphics. Some of them the judge has deemed to be a little bit too offensive for the jury to see, but they are going to see some of the autopsy photos. And again, they'll view it for the value at which it's presented.
Going back, we are going to actually go back to the courtroom now, so let's go ahead and do that. And David, thanks for being with us in studio again.
Stacey, my pleasure.